Yes, Mr. Jethmalani.
My Lord, I was reading paragraph
Instead
237.
of reading the 17-page note, why don't you formulate what the essential points are?
Yes.
Yeah, so that then we can, we know where you stand.
But at the end of each, I was going to make my proposition. At the end of each. So I just finished this.
Why don't you formulate what you have to say so that we'll read the note. There's no difficulty about it.
May I just finish reading 237 and 238, or it's not? Your lordships are familiar with it.
We've already read that judgment.
Continue from your note.
I'll read.
Or if you can formulate what your submissions are, isn't that may be better. If you can.
So as I said, my submission on this aspect of the matter, first, of course, it's not necessary to go into any revisit of the judgment in Nabam Rabia. But the lordships do want to revisit it. It should be for reaffirming the view enunciated, in particular by the decision of Justice Mishra, which is that he's disabled. A speaker or a deputy speaker is disabled for his functions as a speaker at the time of a notice to remove him, and not at a subsequent stage when that notice is under consideration.
Yes.
Now, so that view, my Lord, sir, I'm now reading page 6 of my note, is fortified by the following submissions. The fact that a prior notice of 14 days is to be given, has your lordship's got that, my Lord? I'm at page 6 of my note. Presents every opportunity to those aggrieved by the said notice to thwart the intention of the notice. A speaker or a deputy speaker whose removal is intended will be tempted to take all steps available to him to dissuade or prevent the mover of the motion from proceeding with it further in that 14-day period. So that 14-day period provides him an opportunity which not only is capable of being misused, it had been misused, and I showed that particularly with reference to the facts of the instant case. And that's my second proposition, that subsequent events revealing gross misconduct and partisanship on the part of the deputy speaker, as more particularly set out here, and I'll come to those, during the 14-day notice period, vindicate the view in Nabam Rabia regarding the period when the deputy speaker's or speaker disability under Article 181 commences. Then third, now, my Lord, Article 181 deals with the situation where the resolution for the removal of the speaker is under consideration and prescribes the restrictions on the speaker or deputy speaker that at a sitting, that article is concerned with a sitting of the Legislative Assembly. Please note that, my Lord.
Yes.
At a sitting of the Legislative Assembly, when such resolution is under consideration, then the deputy speaker or the speaker, as the case may be, shall exercise all the powers available to a member of the Legislative Assembly, but not those that pertain to the office of speaker stroke deputy speaker. Now, my Lord, this is logical. I'm sorry.
Yes.
This is logical as the notice for removal is from the office of speaker, deputy speaker, and not as a member of the Legislative Assembly. While Article 181 uses the word any resolution and not notice of intention for removal of the speaker, that is because while consideration of the resolution has to be during the sitting of the Assembly, or it can only be when the House is in session, a notice of intention can be given even when the Assembly is not sitting. So Article 181 itself does not prohibit a construction that a deputy speaker cannot act as such deputy speaker from the time a 179C notice is moved. 181 deals with a sitting for consideration of the Legislative Assembly. And below the rules between 179C and 181, that is notice given and then 181 consideration of the notice, there is a vacuum. That vacuum is filled up by Rule 11 the House itself has made rules as to what will happen in that interregnum. But if the Lordships want, I'll read it very quickly. Rule 11.
That's all right.
Not
We've
this.
seen the rule.
We have seen Rule 11.
So that in short, but not that he has to give a notice 14 days period, and then as soon as may be. But the House rules make it almost impossible for there to be any serious delay in the matter pertaining to disposal of this issue of his removal. Because it's only that 14-day period. Immediately after the 14-day period, he has to refer it to the House. And then, so basically it's 14 days. And
So according to the prohibition, the period when the speaker is barred from considering a petition for disqualification commences the moment a notice is given.
yes.
Commences the moment a notice is given.
And any misuse is circumscribed by the rules of the House, which say immediately after the 14 days almost, you must put it up to the House. If you get 29 members, it will then be considered. You don't get 29 members after 14 days, the issue is dead and then.
All right. What is the next point now?
Then the provisions of Article 181 of the Constitution are based upon the rule against one being a judge in one's own cause. In other words, the nemo judex in cause sua rule. There is no reason why this rule should be restricted to the case of consideration of resolution, but not at the stage of notice, when a speaker who continues to function as a speaker can use his powers as a speaker to alter the constituency that will decide on his removal. So he can gerrymander the constituency that decides on whether he should, if he's allowed to remove them. And that's the whole purpose of. Now, the Lordship will kindly have, what is it that is prevented by 179 or 181? It is that the Speaker cannot preside. He cannot preside over the House. That word is important. By presiding over the House, he gets several powers, which can, my lord, and his powers, at least under our Constitution, are almost paramount. They're unchecked. His is the last word. Regarding procedure in the House and decisions taken, his is the final word. There's no check on it within the House. It's only governed by the rules. That's it. Now, my lord, your lordship may quickly see two rules which have not been pointed out so far. Rules 53 and 58 of the Maharashtra Assembly Rules, PDF 34 and compilation 3C.
Is the PDF page?
PDF 34. 34. My lord, it is the possible abuse of his power to preside that has warranted 181, that has brought 181 into existence. Now, under Rule 53, for instance, I'm just giving an example as to what he can do to scuttle the constituency, to scuttle the number of members who might vote against him. The Speaker may direct any member who refuses to obey his decision or whose conduct is in his opinion grossly disorderly to withdraw immediately from the assembly, and any member so ordered to withdraw shall do so forthwith and shall absent himself during the remainder of the day's meeting. Now, this is a part of suspension essentially. So on that day, on a particular day when he's being voted, he can resort to this power and there's no check. That is why his powers of presiding over the House are suspended when his motion is under consideration for his removal. Now, my lord, by a parity of reasoning, what applies here should equally apply to that 14-day period, because he can scuttle members during that time. In fact, as happened in this case, he can totally ignore the notice at all. A speaker prone to doing that, as he has done in this case, can well scuttle the entire removal procedure. And I'll briefly remind your lordship at the appropriate time as to what he did in this case. So, for logical reasons, there is no ground to distinguish between the 181 stage and the 179 stage. The nemo judex rule will and must apply at both stages. Otherwise, you check him at the 179 stage, but he can scuttle the entire removal motion at the 14-day period 179 stage. '58 is an all. 58 of the rules is his residual power. He is the final residuary authority of all power in the House. All matters not specifically provided for in these rules and all questions relating to the detailed working of these rules shall be regulated in such manner as the Speaker may from time to time direct. So anything that's not provided for in the rules is at his sole discretion. That's how powerful he is. Now, my lords, that's the proposition. The proposition is that the judgment in Nabam Rabia must be reaffirmed and put on stronger ground for the reasons I respectfully submit I have advanced in this note. There may be something to say about the then member's part, but there are stronger grounds. This judgment can be put, this authority can be put on stronger grounds if your lordships are to revisit the judgment. Now, I come to the next factual conspectus, and that is now on 22nd June. On 22nd June 2022, Sunil Prabhu, acting as Chief Whip of the Shiv Sena Legislature Party, issued a notice calling all members of the SSLP to attend a meeting to be held at the CM's residence on the very same day at 5 p.m., failing which consequential action against the delinquent MLAs under the relevant provisions of the Constitution of India would be taken recourse to. The said letter was replied by Shri Eknath Shinde on the same day, disputing the authority of Sunil Prabhu and further stating that Bharat Gogwavle had been appointed the Chief Whip of the SSLP. It was also said in the same letter that the notice was invalid, PDF, page 51. In view of non-attendance by Shinde and other MLAs of the Shiv Sena, an illegal resolution was passed. Now, please note, they didn't attend that meeting. For that very elementary ground, a notice was then issued. A resolution was passed by 14 MLAs of the UT faction to take disciplinary action as provided under. So this is the starting point. Disciplinary action under 10th schedule. For what? For not attending the meeting. Now, my lord, the contention of the petitioner is that the notices issued on 21st and 22nd were validly issued and were binding on all members of the Legislative Assembly. Our contention that the two resolutions of 21st and 22nd were illegal for the following reasons. Prabhu had been removed as the party whip by 34 MLAs of the Eknath Shinde group on 21st June itself. After he had been removed, he issued that notice or notices. The notices were therefore without jurisdiction. Now, very important. Moreover, it is well settled that a party whip can only be issued for actions on the floor of the assembly and not outside the house. The party whips of 21st and 22nd June were misconceived and illegal insofar as their content was concerned. Now, my lord, over here, there's a new document which is not before your lordship, but we have filed it just now regarding the Legislative Assembly debates, the parliamentary debates pertaining to the 52nd Amendment in 1985. I'll just read the speech of one member. What is the reference? But it's the last document on record.
Last document means where? Where is it?
Is it scanned?
We just filed it in the lunch break. I'm sorry, my lord. We just discovered this
All
document.
right, you can just refer to it.
Where is it? Now, my lord, this is the this is the speech. What happened, my lord? And there's another
Who's the
provision
speech by? Who's the speech by?
by Sharad Dighe, one of the members of parliament in the Lok Sabha, who said this. Now, what happened was, originally, the bill had three provisions under 2. 2A as it presently stands, 2B as it presently stands, and 21C. There was a third provision. That third provision permitted disqualification for activities outside the House. Now, I haven't got the exact provision, but I'll get it by this evening and tender it. Because we only just discovered this. The third one was removed. By debate, it was deleted. 21C was deleted, and your lordship will just see one. It's at PDF 38. Your lordship can just note. Where is the marked part? This is what he says. This is what Mr. Dighe says in the parliamentary debates of 1985. I'm reading from the parliamentary debates. Now there have been several clauses in this bill, and I am happy that the law minister has also announced that 2 of the clauses are to be amended. As far as clause 2, subclause 1, paragraph C is concerned, that has to be deleted, and paragraph B has to be amended suitably. It was very much necessary to delete paragraph C because if a member has to be expelled from a political party in accordance with the procedure for anything done outside the House, it would have created several practical problems, and it would have given a handle specially to the bosses of smaller parties where this paragraph would have created some difficulties. Therefore, the main principle of this disqualification is that for something which a member does in this House, in the presence of this House, such as voting against the party or abstaining from voting against the direction of the party. Now, this is something which is proved beyond doubt. No other inquiry is necessary by any other committee or anybody else. So it is very clear that any act done by a member in the presence of a presiding officer, namely voting or abstaining from voting, would entail him to this disqualification. So there is no injustice, no chance of any injustice being done, nor is there scope for any doubt whether he has committed that act or not. Therefore, from that point of view, acts done outside the House have been deleted or are proposed to be deleted now because there would have been the question of proving them. Some doubt may arise, and there will be the question of giving a hearing to the member. Also, the rules of natural justice would have to be followed. So, the whip squarely applies for disobedience on the floor of the House. It doesn't apply to acts outside the House. This is not to say that 21A is out. 21A is still there.
But isn't that on the merits of the disqualification petition?
Yes, that's
This wouldn't really help you at
right
all.
now, I'm not on the.
Because therefore your contention would be that, well, the disqualification was not attracted. But even assuming that is so, that's the jurisdiction of the speaker.
Yes, your lordship is right.
It's exclusively within his
So therefore, what is being done in this case, or proposed to be done, because it was never acted upon, what was proposed to be done by the letter seeking my disqualification was to bring in through the back door a 21A situation, which is because this was an act outside the House, which is prohibited. 21C, legislative intent was to take out 21C.
Then, Mr. Jethmalani, in that sense, Mr. Sibal's argument was that this was a per se disqualification. You're now dealing with a per se disqualification on merits. Your argument all along has been, the argument of your side has been, don't go into the per se disqualification argument at all because it lies within the domain of the speaker to decide. Now you're really by going into the merits.
Actually, this is purely.
No, my lord, at the moment, I'm not at this moment, I'm not on the disqualification petition, which I will come to.
You are inviting us to go into Mr. Sibal's argument as to whether there's a per se disqualification.
But I'm not.
He's right. He may be right on that.
But at the moment, I'm not on the disqualification petition. I am on the 2 letters which are sent to me. Please see that.
Oh, why should we go into the merits of the disqualification at all? Because once you say
all right,
that disqualification lies exclusively within the domain of the speaker, then perhaps then
So-
it would be internally inconsistent for you to argue that, well, there was no disqualification.
There were
based
two
on-
grounds in the disqualification petition, and they were both based on this letter.
But you
So
can very
that
well
would have
counsel,
been your-
stop at the place where you can very well say that, yes, sir, it is to the prerogative of the speaker to consider, we will, why should we? That
It
is
can
not
stop.
10, mister.
It can stop there. Your lordship is absolutely.
Don't try to justify whether there was a disqualification or not.
I agree. I don't need to go that far, but since those two letters were the very grounds of my disqualification,
Okay, Mr. Bichar.
All right. What is the
Proceed
next
further.
point now?
What is
Mr.
now the next one.
Mr. Jethmalani, what was the page number since we've got that downloaded, airdropped to us? Just tell us the page.
I'm saying Nabam should be
No, no.
reaffirmed.
The speech,
On last debate.
the debate that you referred to of 85, it's been airdropped to us just now. Just indicate the page, please, for us.
Yes.
What page?
It's been said
Page 38. Page 38.
38.
38. All right.
Now the second. Now don't bring these serious matters.
What's the next point?
The next point is that the fact of 34 MLAs being part of the real recognized Shiv Sena, and this is more substantial, was disclosed to the Deputy Speaker in the said MLA's letter on 21st June, wherein they had enclosed the resolution of the same date,
Yahan par hai.
which clearly spelt out
Mr.
that
Chairman, which part?
I'm reading now at P11.
P11.
P11 is written.
What happens?
Page 11.
Yes. The second point.
All right.
That the fact of respondent 34 MLAs being part of the real recognized Shiv Sena party was disclosed to the Deputy Speaker in the said MLA's letter on 21st June, wherein they had enclosed the resolution of the same date, which clearly spelt out that they were the real Shiv Sena party. The Deputy Speaker ought inter alia to have desisted from proceeding any further with the disqualification petitions, as it should have been obvious to him that there being now two groups, each claiming to be the recognized Shiv Sena, the dispute on the issue was a matter which was squarely within the jurisdiction of the Election Commission under Clause 15 of the Symbols Order. So, my lord, the proposition here is that once the claim is made that we are the real Shiv Sena, as opposed to a second group, that we are, in other words, that we have both legislative and organizational majority or heft, the Speaker should desist from proceeding further with a disqualification proceeding pending an adjudication by the ECI, because the Speaker can only go into legislative matters. He cannot go into the organizational situation. In the facts of this case, I may say one more thing. In the facts of this case, all the MLAs in this case, all MLAs, this is part of the party constitution. All MLAs, all MPs of every house are ex officio members of the Pratinidhi Sabha, which is the supreme organizational body of the Shiv Sena. So even if the Speaker in this case were to adopt the twin test, the second one being the organizational issue.
But Mr. Jethmalani, this point Mr. Kaul has also already made, that it is not the case of your side that there was either a split or merger in the political party. The contention was that a rival faction in the Shiv Sena represented the real Shiv Sena.
Real Shiv Sena.
And this has now been found to be true and correct by the subsequent
by the ECI.
Right.
So, my lord, a question was posed.
But therefore, Mr. Kaul has made that point. I don't think you need to.
So the question was posed whether what should be the conduct of the Speaker when such a situation has been pointed out to him.
You are saying
not a split.
You are saying that he has no jurisdiction at all.
He has no jurisdiction. He must submit to the jurisdiction of the ECI. He should desist from pursuing the disqualification proceedings further. Now, my lord, we come to the very important aspect of this matter, which actually takes out the foundation of the applicability of Nabam Rabia. Now, on 24th June 2022, the Deputy Speaker wrote an email to the advocate for the 34 MLAs in response to their notice of 21st June under Article 179C, stating that he could not recognize the email ID from which the notice under 179C was sent. Therefore, he would take no further action until and unless the genuineness or veracity of the said signatures on the letter or the email ID is ascertained. So, in fact, he ignored Nabam Rebia, or ignored it on extremely specious, frivolous grounds, that I could not recognize it and I would wait for verification. That verification was never communicated. So where is Nabam Rebia even involved in this case? You either ignored the dictates of a constitutional bench judgment, or alternatively, you ignored it, you rejected it on the basis of extremely flimsy grounds. But in any event, you never acted upon it. That notice under 179C never ever obstructed the speaker from what he went on to do, because he contemptuously ignored it on specious grounds. And he disobeyed the then mandate. Nabam Rebia was good law and he ought to have obeyed it. So now this is the real nub of the issue, when the whole case is one of deemed disqualification. And Nabam Rebia is invoked because of that notice under 179C. That you hindered me in my job as speaker by issuing that notice, notwithstanding the fact that Nabam Rebia was good law. In fact, you were not hindered. Factually, you were never hindered, because you tossed my notice into the dustbin. But that's the end of anything further. Your deemed disqualification doesn't apply now.
Right.
Okay.
Then, my lord, something very important starts from 25th June. On 25th June, the Deputy Speaker issued summons. Now, my lord, all along, we are told that there are 39 MLAs. Your Lordship has made all those calculations on 39 MLAs. Now, my lord, there's a serious issue here. The Deputy Speaker on 25th June issued summons to 16 MLAs only, informing them that a disqualification petition has been filed against them, which was served along with all annexures only on 16 MLAs. Now, for the first time, they inform us. Remember, this is a very serious issue. First time they inform us is on the 14th of July, when a disqualification petition allegedly dated 27th June. Now, I will point out the pleadings very briefly, or I'll just point out there has never been any reference to a 27th June disqualification petition. Admittedly, it was not served on us. Admittedly. The so-called 27th June petition for disqualification of the remaining 23 MLAs, apart from 16. Lordship remembers there were 39 MLAs. 16 MLAs has been the theme throughout. Even during the hearings in the Supreme Court, which they've carried against. The hearing in the Supreme Court on the 29th and the 29th, when they moved the Supreme Court to challenge the governor's decision to call for a floor test, even on that date, the reference was only to 16 MLAs. But in arguments, it is being sought to portray that all 39 MLAs were received disqualification notices. Now, there's a second aspect here, a legal issue. The Lordship turns to page 12. Regarding that notice, regarding the disqualification petition. In every pleading, your Lordships will note that contrary to what is being suggested to your Lordship, in every pleading, there is no mention of the remaining 23 MLAs. That is a matter which has misled this court. I had no idea myself till it was pointed out. I assumed that was always 39 MLAs. But it has throughout been, and there's a reason for that. There's good reason why they only served these disqualification notices and petition to 16. Because they wanted to split the two camps. 16 still made it possible for them to survive a majority on the floor of the House. 39 most certainly didn't. So till the last minute, they only talked about 16. It is only after the new government came into existence, the new speaker was appointed, the new government came into existence, that they referred to 39 MLAs.
We'll just get up for 2 minutes.
Yes, sir.
The Chief Justice of Kenya has to have other meetings, and we'll come back in 2 minutes. So according to it was only after the new government came.
For the first time in a petition, your lordships may note, of 14 July, sorry, 8th July, yes, which they filed before this court. In that 8th July petition, they said 39 MLAs totally, and they referred to a disqualification petition of 27 June, which nobody was served, and they never referred to any of their earlier pleadings. Now, this whole exercise on 16 MLAs would never have taken your lordships so many days, unless you all wanted to revisit Nabam and all that. But on facts, if they had been fair and said there were only 16 MLAs disqualified at all times and not more, the situation was purely academic. And the reason is malafide. Why this division? The reason is malafide. You wanted to split the two. You were hoping that you would get back 23 of them and your majority would survive. That is why only 16 MLAs. But when the government fell, that necessity didn't arise. When that government fell, that rationale had gone. Now you wanted to topple the whole government. Now, on this disqualification issue, a second major fault on the part of the speaker. He gives me 2 days to reply. Now, that is very important. A little factual digression is necessary, but it is a little law and a little factual, because this is very important. But this reveals malafide on the part of the speaker in the extreme. Sorry, deputy speaker. Incidentally, there was no speaker for 2 years in Maharashtra.
There was no speaker at all.
Yes.
The deputy.
Now, my lord, within 7 days, please see Rule 73B. It said PDF 129 JC1. Sorry.
What does Rule 73B say?
Yes. Statute compilation.
15 days, right?
7 days.
7 days.
Okay, that's fine. We can go. But that's all I want to point out. Really, it's 7 days. But what is important is, whereas the Maharashtra Assembly rules may be subject to Article 212, which says irregularities of procedure can't be looked at by a court. Mere irregularities. If it's a serious irregularity, the latest judgment of Justice Khanvilkar's three-judge bench says that if it involves a question of natural justice in another Maharashtra Assembly case, then it's escalated to the level of a constitutional provision which must be obeyed. And the violation would be 1421, etc. But as far as the disqualification rules are concerned, and when I talk about 73B at page 12, this is not part of the assembly rules. This is now part of the disqualification rules. And these are framed under paragraph 8. And my submission is that these rules are mandatory, and any breaches of them by a speaker stroke deputy speaker are not immune from judicial review as per other procedural regulations under 208. Whose effect are diluted by 212. Now, just two paragraphs of two different judgments. Actually, I've set out, but your lordships may just see Kyoto's judgment. PDF 129, judgments compilation 1.
You are referring to these Kyoto and Shrimant to say that principles of natural justice is mandatory. There's no dispute on that. Take that point.
Not just that, it's a specific reference to the. I'll just read one paragraph. Your lordships will see what I'm getting at. Para 97 in Kyoto, page 129, PDF 129.
Para 97.
Yes. It's not just the rules pertaining to natural justice. Paragraph 8 rules are all immune from the dilution provided by Article 212. Because these are, I'll tell your lordship, the reasoning comes there. Please see that. That's why I want your lordship to just see it. The reason is contained in paragraph 96. That apart, even after 1986, when the 10th schedule was introduced, the Constitution did not evince any intention to invoke Article 122 or 212 in the conduct of resolution of disputes as to disqualification of members under Articles 191 and 102(1). The very deeming provision implies that the proceedings of disqualification, the deeming provision says these shall be deemed to be proceedings of the House. The very deeming provision implies that the proceedings of disqualification are in fact not before the House, but only before the Speaker as a specially designated authority. The decision under paragraph 6(1) is not a decision of the House, nor is it subject to the approval of the House. The decision operates independently of the House. A deeming provision cannot by its creation transcend its own powers. There is therefore no immunity under Articles 122 and 212 from judicial scrutiny of the decision of the chairman, speaker or chairman exercising power under paragraph 6(1) of the 10th schedule. Now, my lord, 6(1) includes the whole gamut of procedure, starting with the petition for disqualification. The entire gamut of the procedural provision 6.1 and your lordship will then just see 8.
Para 6.1, right?
It says, subject to the provisions of subparagraph 2 of this paragraph, the chairman or the speaker of a house may make rules for giving effect to the provisions of this schedule, and in particular, and without prejudice to the generality of the foregoing, such rules may provide for, and your lordships may kindly turn to D. D. The procedure for deciding any question referred to in subparagraph 1 of paragraph 6. So when my learned friends talk about the Supreme Court intervening with that notice period, which is prescribed, I'm talking about the 27th decision, which is prescribed under rules framed under 8, i.e. 7.3b, the Supreme Court was fully justified. The bench of that day was fully justified. Apart from the fact that it ill behoves a legislative assembly to say that rules framed by it under a constitutional provision can be blindly ignored by it. They're the legislators. If they set that precedent, God save the rest of the country. Now, my lord, even in the latest case of Shriman Patil, I'll just read it from my note, the relevant provision. Even the latest case of Shriman Patil, hello, that was the, I'm now at the bottom of page 12 on D. I'm on D. Even in the latest case of Shriman Patil, this was the, I believe, the Karnataka Assembly case, where time for a reply to a disqualification petition was contrary to the rules of the Karnataka Assembly, the court held in paragraph 190.7 as under. Our findings on allegations of not granting specific time in all the above cases are based on the unique facts and circumstances of the case. But actually, after Kyoto's case and the elevation of those rules under paragraph 8, there should never have been any leniency in time given to file a reply to a disqualification notice. You are affecting not only the MLA but his constituency. It should not be understood to mean that the speaker could cut short the hearing period. The speaker should give sufficient opportunity to a member before deciding a disqualification proceeding and ordinarily follow the time limit prescribed in the rules of the legislature. So an exception was carved out in that case, but even so, the principle was reaffirmed that the rules are mandatory. Now, my lord, on the one hand, a disqualification petition is given to us. The speaker ignores Nabam Rabia. 2, he gives me a 2-day instead of a 7-day period. 3, what happens? Now, my lord, kindly see. I'm now on 13, and this is a very important aspect. While those disqualification proceedings are pending, everything is done to prevent me from coming for a hearing. Please see. Now, my lord, I would request your lordships, this is the prelude to my petition before this honorable court on the 27th. This is what actually happened. I did pray for staying of the disqualification proceedings, and in my respectful submission, even had a quia timet, my learned friend Mr. Kaul pointed that out, even if a quia timet injunction had been granted restraining the speaker from pursuing the disqualification proceedings on the ground that a constitutional provision, i.e. 179C, was being ignored. Because Nabam Rabia was the law at that time. Right? Even if they had done it, which they didn't do, there would have been nothing wrong with it. What they actually did ultimately was only confine the reliefs granted to police protection, and I'll come to your lordships why, and the time period extension from 7 to 14, from 2 to 12 days. Now, my lord, your lordships will kindly see the threats that were given to me. First, your lordship will kindly see, and this is very important because I couldn't come. They prevented me from dealing with my disqualification application. First, they ignored the 1979C. They chucked it to the dustbin. Secondly, they gave me practically no time, 2 days. And then, kindly see the threats that were issued to me. Now, the first one your lordship may see is 24th June.
Not necessary to read the threats.
You've relied on para 97 of Kyoto. You've also distinguished.
But very important.
We take it that it was compelling for you to come to
Yes,
the court.
but I'll summarize what those threats were. First of all, my lord, security to, I was out of Bombay. Security to my family members was withdrawn. Death threats were being given, security was withdrawn, and publicly there were pronouncements of the leaders of the Uddhav Thackeray faction that if I come back to Bombay, if I come back to Mumbai, my bodies would be sent straight to a crematorium. That's the nature of threats. In view of that, I had to move the Supreme Court for multifarious reliefs. Out of those, on the 27th, only 2 were granted. There were serious death threats. My lord, one of them, a gentleman called Tanaji Sawant, an MLA, I think he was the minister of the government when the government was united. His office was burnt. It was the most serious situation at that time. And kindly see the response. Now, I don't want to tread on the solicitor's province. But your lordship may just see the letter of the governor at that time. Because, my lord, this shows the kind of information that the government was always receiving, continuously receiving, which ultimately culminated in his decision to cause a flaw test. Page 306 PDF.
Sir, it was read and reread. That letter to the governor was read and reread. Correct? So we know that these are the things. Correct. Earlier there is a threat, and earlier there was a coalition government. There is a breach. Everything has been read. Mr.
No, this letter pertains to the governor saying the situation is extremely serious.
Correct. That we have.
Please give them security. Look, we're talking now about a speaker and a government that ignores a constitutional mandate. I just want to see what is happening. The thread. You throw out the leader of the legislature party. He gives you a notice fearing disqualification under 179C. You ignore it on completely specious grounds. Then you serve me the next day. You serve me a disqualification petition for 16 MLAs. Divide and rule. When I get that disqualification petition, in the notice you say, reply within 2 days. Contrary to rules, mandatory rules. And finally, you prevent me from coming to Mumbai. I'm entitled to a hearing. You prevent me from coming to Mumbai with death threats and withdrawal of security to my wife and children and burn houses. Conduct of the speaker, therefore, needs to be, my lord, that's the only reason why, notwithstanding that the fact that the factual basis of this case doesn't warrant any legal relook at Nabam Beria, because as I said earlier, Nabam Beria was never an issue because the notice was never ever acted upon. Notwithstanding that fact, restrictions circumscribing misuse of power by the speaker need to be imposed. And Justice Mishra's judgment in Nabam Beria needs to be reaffirmed. So I'm not going into the governor's letter.
What else, Mr.?
I'm not under Article 164(2). My learned friend talks about a very high constitutional principle. He elevates the entire conspectus of this case to the evil of defection. The evil of a speaker and a government hell-bent upon power is an even greater evil. But there's a constitutional principle, which the Lordship just look at G at page 14. The principle emanates from 164(2), which says that the Council of Ministers are collectively responsible to the Legislative Assembly of the state. What does this mean in practice? It means that when the Council of Ministers collectively lose the support of the majority of the House, they have to step down. So, my lord, much higher than the evil of defection is the principle of majority rule in this country. That is paramount. And the principle of majority rule is to be found, there are judgments on 164(2), is to be found in 164(2). That when you, and that's why the governor is given the right to form a new government headed by that person, not headed by a political party, headed by that person who commands the majority in the House. And he has to ignore, says Rameshwar Prasad and Shivraj Chauhan, which my learned friend Mr. Kaul read out. He has to ignore the fact of any potential disqualification of those members who might support the new government. Now, my lord, at page 15, your lordships may note point 2, H, main heading H, Supreme Court refused to grant stay on floor test. And 2. Well, these two, I'm not going to read these petitions, but they say there are only, on 29 June, and they say that there are only 16 MLAs disqualified. That is the last date on which anything could have affected them. 29 June itself, the petition was for disqualification of 16 MLAs. As I said, the 16 MLAs issue came only on, and till today we don't know the number of that petition. It was allegedly filed. It was allegedly filed before the Deputy Speaker. We do not know the disqualification petition number till today. It is placed before your lordships. What's the page? I'll just give your lordship the page. Never served upon us. But the contention is 39 MLAs all along. Now, just the last three points very briefly. At page 16, J, K, and L. The floor test was never held. Although there's some limit to causation in the law. To say that Mr. Uddhav Thackeray resigned because of all that went before is, my lord, stretching credulity to the nth degree. He resigned because he knew he had lost the majority. But, my lord, there has to be, this is too remote a cause in law for that to be a consequence of all that happened before. He voluntarily stepped down. Now, my lord, JKL, I'll just read it out quickly and then I conclude. The question of deemed disqualification. There is no such concept as a deemed disqualification disqualification has to be actual, and there is a mandated procedure for disqualification proceedings. My lord, I request your lordship to just indulge me and read Rule 7.7. Page. This is under the disqualification rules, not now under anything else, and not under the assembly rules.
Page 10.
7.7, your lordships were referred earlier. Sorry. Your lordships were referred earlier to 7.3b, which was that notice period. Now, 7.7 is the rest of the procedure. Please have a look at it. And for the question of deemed disqualification. Now, it's page 12 of the statute compilation volume.
Yes, sir.
This must be quite threatening.
Huh?
Our presence must be quite threatening.
Acha, you said presence.
Presence.
We have heard patience.
No, no.
We thought our patience.
We are yet to follow. Then.
No, it's okay.
7.7.
You are on 7.7.
7.7. The procedure which shall be followed by the speaker for determining any question, and the procedure which shall be followed by the committee for the purpose of making a preliminary inquiry under sub-rule 4 shall be, so far as may be, the same as the procedure applicable for the determination by the committee of any question as to breach of privilege of the assembly by a member, and neither the speaker nor the committee shall come to any finding that a member has become subject to disqualification under the 10th schedule without affording a reasonable opportunity to such member to represent his case. There has to be a mandatory hearing in this matter. There cannot be a disqualification without a hearing. Therefore, to talk about a deemed disqualification in the absence of a hearing is to suggest this. Now, my lord, it is suggestive, my submission on this point. A deemed disqualification is suggestive of a contention that the reply of a delinquent MLA and the hearing which he has a right to before the speaker are both empty formalities. It further suggests that the speaker would be necessarily of predetermined mind and partisan bent. To deem disqualification, that means the hearing is an empty formality. Something which a litigant who claims to be upholding lofty ideals and unbiased procedure should be loath to canvass. Then, my lord, equally untenable is the contention of dating back of a disqualification. The judgments in both Rana and Patil are no authority for setting the clock back on all events that took place up to the date of the action which made an MLA liable for defection. A plain reading of those judgments, well, Mr. Kaul has read them out, clearly reveal, see for example Rana's case in paragraph 34, that the speaker has to decide. That's all that Rana is authority for. The question of disqualification with reference to the date on which the member voluntarily gives up his membership or defies a whip. It is really a decision ex post facto. The phrase ex post facto does not entail retrospective operation. The argument also completely ignores Articles 189(2) and 191(2) of the Constitution, both of which clearly indicate that an order of disqualification only had retrospective effect. Particularly important, my lords, is 191(2), which says he shall be disqualified when he is disqualified. It has only disqualification only has prospective effect, not retrospective effect. And lastly, my lord, L, I've already taken this point, so I won't repeat it. But I'm deeply grateful for a very patient hearing.